Hello to all our friends at the Academy, and a warm welcome to those of you joining us for the first time. I am Professor James from IntlLaw Academy of International Law. The playlist I am preparing for you will focus on the relationships among the subjects of international law. Together, we will explore how these subjects interact, what kinds of relations they form, and how international law regulates and organizes these interactions. If you're not quite ready to begin this new playlist, I recommend that you first watch the 3 playlists of introduction, sources, and subjects of international law on the Academy's channel. These were prepared by the other professors of IntlLaw. But if you have already completed those and are ready to start this new journey with me, click on my playlist above to catch up the previous videos if you want. Or let's dive into today's video by talking more about friendly relations in international law. If you remember the last videos, we have explored the mechanisms under the UN Charter for addressing violations of the prohibition on the use of force. And now in this video, we are going to talk about the practice of states and the precedents set by UN operations to suppress violations of the prohibition on the use of force. We can examine this subject in 2 main contexts: the responsibility to protect, R2P, and counter-terrorism measures. Let us begin with R2P. The responsibility to protect emerged as a legal and political concept to guide the international community in protecting populations from the most serious crimes: genocide, war crimes, ethnic cleansing, and crimes against humanity. The concept was first articulated in the 2005 World Summit Outcome document, which formally recognized the international community's role in protecting populations when their own governments failed to do so. In 2009, the UN Secretary-General outlined 3 practical conditions for implementing R2P, and by 2010, his report emphasized 3 key principles. First, early warning of potential atrocities. Second, assessment and monitoring of the situation. And third, R2P as a measure of last resort, applied only when peaceful measures have failed. By 2011, informal discussions in the General Assembly refined the role of regional and sub-regional organizations in executing R2P, complementing the Secretary-General's reports. Finally, the framework of R2P follows a tiered responsibility. Primary responsibility rests with the state itself, which must protect its population. And secondary responsibility lies with the international community, which may act when the state fails vows. The approach emphasizes diplomatic, humanitarian, and supportive measures first. Only if the state fails to uphold its responsibilities does the international community intervene, in accordance with the principles of sovereignty and non-intervention. Since 2009, R2P has been structured around 3 pillars, which are now the official interpretive framework. The first pillar is state responsibility. Every state has the primary responsibility to protect its population from the 4 atrocity crimes. The second pillar is international assistance. The international community must help states fulfill this responsibility through capacity building, diplomacy, development aid, and institutional reform. And the third pillar is timely and decisive response. If a state manifestly fails, the international community must act collectively, primarily through the Security Council. This framework clarifies that R2P is not mainly about military intervention, but about prevention and assistance. In practice, the UN increasingly treats R2P as a preventive doctrine, not a reactive one. Key preventive tools include early warning systems, human rights monitoring, mediation and political dialogue, electoral assistance, and institutional reform. This reflects a shift from intervention after collapse to protection before catastrophe. The Security Council has applied R2P in practice through several resolutions, like Resolution 1674, Darfur, Sudan, which marked the first explicit Security Council reference to R2P, Resolution 1970, Libya, and 1973, which authorized NATO intervention and further operationalized this principle. After NATO's intervention in Libya 2011, many states, especially Russia, China, and Global South countries, accused Western powers of abusing R2P for regime change. As a result, R2P lost political momentum, Security Council consensus weakened, and Syria became a symbol of paralysis. This political backlash is crucial for understanding why R2P is rarely used today. In response to Libya, Brazil proposed the responsibility while protecting (RWP) in 2011. It demands strict proportionality, continuous monitoring, accountability of interveners, and limits on mandate expansion. Although it is not formally adopted, it reflects ongoing efforts to discipline R2P. The other important point is that R2P differs from the collective security system. While the collective security system focuses on immediate action by the Security Council, R2P is primarily preventive and protective, with the use of force considered a last resort after diplomatic and humanitarian measures. The aim is deterrence and post-conflict reconstruction, not only punitive action. At the end, we should mention that in practice, regional organizations play a central role in R2P as well, such as African Union, ECOWAS interventions, or Arab League positions. This shows that nowadays, R2P is no longer purely UN-centered. Okay, the other subject of our today's video is counterterrorism measures. International law still lacks a universal definition of terrorism, even in the Rome Statute of the ICC, which has been amended but still does not define terrorism explicitly. Likewise, 14 major conventions addressing terrorism provide no comprehensive definition. But despite this, the UN and states have developed a practical legal framework for counterterrorism. The 1990 International Convention for the Suppression of Terrorist Bombings sought to codify certain rules, although it was not universally ratified. UN Security Council Resolution 1368, 2001, adopted after the September 11 attacks, was the first to recognize terrorism as a threat to international peace and security. And Resolution 1373, 2001, established obligations on states to prevent and suppress terrorism, linking it to broader international security. Resolution 1373 is revolutionary because it imposes binding legislative duties on all states, requires criminalization of terrorism financing, mandates asset freezing, regulates migration and asylum. It is often called global legislation by the Security Council. The UN has built a complex institutional system in this matter as well. Key bodies include Counter-terrorism Committee, Counter-terrorism Executive Directorate, UN Office of Counter-terrorism. These bodies monitor compliance, provide technical assistance, and evaluate national legislation, turning counterterrorism into a permanent governance regime. In the practice of the United Nations and its member states, counterterrorism measures have always been accompanied by a deep and persistent tension between the requirements of security and the protection of human rights. After the adoption of Security Council Resolution 1373, 2001, states were obliged to criminalize terrorism, freeze financial assets, strengthen border controls, expand surveillance mechanisms, and restrict the movement of suspected individuals. While these measures aimed at preventing future attacks, they also significantly expanded governmental power over individuals. In many cases, emergency laws, preventive detention, mass surveillance, travel bans, and secret blacklists were introduced without sufficient judicial oversight, raising serious concerns regarding due process, privacy, freedom of expression, and the right to a fair trial. This tension has repeatedly been reflected in international and regional jurisprudence. A well-known example is the Kadi case before the Court of Justice of the European Union, in which UN-imposed sanctions were found to violate fundamental rights because individuals had no effective means to challenge their listing. As a result, the United Nations gradually began to emphasize that counterterrorism must be conducted in full compliance with international human rights law, refugee law, and humanitarian law. Today, the dominant UN discourse insists that security and human rights are not contradictory, but mutually reinforcing. However, in practice, this balance remains fragile, and counterterrorism continues to be one of the main areas where states test the limits of lawful restrictions on individual freedoms. In contemporary international relations, terrorism is increasingly connected with the activities of non-state armed groups operating within complex conflict environments. Unlike traditional interstate wars, modern conflicts often involve armed movements, militias, insurgent groups, and transnational networks that combine ideological motives with territorial control and criminal activities. Groups such as ISIS, Al-Qaeda, Boko Haram, and al-Shabaab have not only carried out terrorist attacks, but have also exercised quasi-governmental authority over territories, populations, and economic resources. This development has blurred the classical distinction between terrorism, insurgency, and armed conflict. As a result, the United Nations and states now increasingly approach terrorism through both the lens of criminal law and the law of armed conflict. In some situations, counterterrorism operations are treated as law enforcement actions, governed by human rights standards. In others, especially where organized armed groups control territory and engage in sustained hostilities, international humanitarian law applies. This dual legal framework creates serious interpretive challenges. It raises questions about the status of fighters, the legality of detention, the treatment of civilians, and the limits of military force. Consequently, terrorism has become not only a security threat, but also a structural element of modern warfare, reshaping the legal architecture of international peace and security. One of the most significant developments in international law since 2001 has been the growing practice of using armed force against terrorist groups operating in foreign territories. Traditionally, Article 51 of the UN Charter allowed self-defense only in response to an armed attack by another state. However, after the September 11 attacks, many states began to argue that large-scale terrorist attacks could also trigger the right of self-defense, even when committed by non-state actors. This interpretation was reflected in Security Council Resolutions 1368 and 1373 and gradually expanded through state practice. Based on this evolving approach, several states have justified cross-border military operations against terrorist organizations under the so-called unwilling or unable doctrine. According to this theory, if the territorial state is unable or unwilling to suppress terrorist threats, the victim state may use force in self-defense within its territory. This justification has been invoked in operations in Pakistan, Syria, Iraq, Yemen, the Sahel region, and Gaza. Nevertheless, this practice remains highly controversial. Many states and scholars argue that it weakens the prohibition of the use of force and undermines territorial sovereignty. As a result, the use of force against terrorist groups abroad represents one of the most contested and transformative areas of contemporary international law, situated at the intersection of self-defense, sovereignty, and global security governance. Okay, that's it for today. At the end, I should say, through such mechanisms, R2P and counterterrorism measures, the UN system and member states develop practical tools to enforce the prohibition of the use of force, ensuring that violations do not go unchallenged. In short, the combination of collective security, self-defense, responsibility to protect, and counterterrorism efforts forms a multifaceted approach for maintaining peace, protecting populations, and upholding the prohibition of force in international law. Thank you so much for accompanying me.